I'm Matt Bishar with NAREITREIT.com here in Washington, D.C. at the Marriott Marquis for the 2016 NAREIT REITWise Law, Accounting, and Finance Conference. Joining me today is Ettore Santucci, partner with Goodwin Procter. Thank you so much for joining us today.
Pleasure. Thank you for inviting me.
Now, let's start. In your opinion, what SEC guidance do you think has had the biggest impact on REITs since last year's REITWise conference?
Well, I'm going to answer the way that you did not expect me to, because it's a piece of guidance that they have not given, and we would really very much appreciate it if they did. There's been a statute called the FAST Act. You may have heard people talk about it. The FAST Act, which has to do with transportation infrastructure, something or other. But it also happens to contain some relief aimed at emerging growth companies. It goes back to the Jobs Act and things like that. And it includes relief for emerging growth companies, a bunch of different things, but two that are particularly useful are relief from including in a registration statement for an IPO financial statements if you know that by the time you launch the deal, they will be not required. So a perfect example is you file in late 2015 and you know you're not going to go effective until mid-2016, and you would have in 15, before the FAST Act, you would have to file 3 years worth of audits. You know that the last year out is going to fall off and 15 is going to come in, and so you're allowed to not bother with the third year out. Nice, useful, not earth-shaking. For some reason, F1s, foreign issuers, are included. S1, emerging growth companies, are included. S11, which is what REITs use, is not. Why? No good reason. They just didn't. Nobody thought about it. The statute and everybody. There's absolutely no reason why REITs shouldn't be included, but they're not. And so the piece of guidance, which may have to be regulation, that we would love the SEC to give, is to say there's absolutely no reasons why Facebook and the next Facebook is entitled to this and the next REIT isn't.
And your firm represented NAREIT in a recent U.S. Supreme Court amicus brief. Can you summarize the issue as well as NAREIT's comments to the court?
Well, let me tell you what the issue is. The issue is, as you know, there are two ways to get into federal court. One is on federal question, securities laws. The other one is on diversity jurisdiction. If I am a Massachusetts resident, drive over a Texan, and I can, or whatever, that's Globe Quarry. But in any event, I can choose to go into Texas federal court because we're diverse, as opposed to going into Texas state court, which is his state. So that's diversity jurisdiction. And forever, corporations have not been deemed citizens, quote unquote, of the states in which their shareholders reside. Otherwise, IBM is a citizen of the world, literally. Partnership, on the other hand, have been held by the federal jurisprudence, citizens of every state in which their partners reside. So if they have partners in 50 states, they have diversity with precisely nobody. And they can't get into federal court on diversity. So the issue arose, what about business trusts? Are they like corporations or are they like partnerships? Old jurisprudence in many circuits is that where the trustees are citizens determines the citizenship of the trust, which kind of makes sense. So we, NAREIT, argued that certainly for listed REITs, they should be treated like corporations, as they are for every other purpose. Why is a REIT that is a trust going to be treated differently, a Maryland trust going to be treated differently than a REIT that's a Maryland corporation? It makes no sense. They're both listed. They are managed like corporations. There's limited liability for shareholders. They have thousands of shareholders, blah, blah, blah. So we said it should be either a facts and circumstances test or some bright line tests that if you are like a corporation, you should be treated like one. If you're like a partnership, you should be treated like one. Unfortunately, the Supreme Court, this is where sometimes they prefer to adhere to 19th century doctrine than to 21st century reality, because they said, well, everybody knows what a trust is. Well, I should be more respectful of the justices of the Supremes. Everybody understands that a trust is different from a corporation, just like everybody understands that a partnership is different from a corporation and a trust is more like a partnership. And therefore, a trust is a citizen of every state where the trust beneficiaries are. Result, Vornado, who happens to be a trust, is a citizen of probably every single state. and therefore they are shut out of federal court on diversity grounds. They can still get into federal court on class actions for securities litigation, things like that, but not diversity.
Ettore, as always, thank you so much for joining us.
Always a pleasure.
For more from REITWise 2016, be sure to visit REIT.com.